Chapter 13. Now, you're gonna probably hear me say this a couple of times. There's an awesome chart that Mark put together in the printed materials. And the chart really kind of lays out a lot of the key differences between Chapter 7 and Chapter 13. So be sure to check that out. So after we finish talking about those differences, we'll discuss homes and cars. This will be our staying and going section, where we'll get into issues with real property and bankruptcy, so mortgages, taxes, and judgment liens. Also bankruptcy as a solution to issues with heir property, which is a term that Jay is going to tell you about. Then we'll talk about residential leases in bankruptcy, and repossessions and choices and options both within and outside of bankruptcy. Finally, we will talk about some issues that people might be dealing with all at once. I'm sure that when folks come to you with problems, a lot of times it will be like folks who come to our firm, Bowman, where they're getting hit with stuff from all angles. But we're going to talk about state court collections, payday, title, internet loans, a little bit about student loans, and also medical bills. All right, Jay, you want to talk about some exemptions?
Sure. So the reason we're going to talk about exemptions is, of course, if your client is exempt, their property is exempt, then they may not need to file bankruptcy. So that sort of goes into the whole equation about whether somebody needs to file. And the first thing I want to just mention was the real estate exemption was increased to $25,000, meaning this is when somebody gets a judgment against you. And well, excuse me, this is the real estate exemption flat out, which was about 2 or 3 years ago. This was changed. Used to be $5,000, went up to $25,000. The personal property exemption is still $5,000, can be more under certain circumstances. And then the other thing, the big change, which really affected all this, is that it's not a lifetime exemption anymore. Now you can actually claim the maximum every 8 years. So next slide. Wage garnishment, this is a pretty big change. You know, Virginia's always had 40 times the minimum wage as the exemption for wages, which is actually higher than the minimum. The federal law requires 30 times. We have 40 times the minimum wage. The reason this has changed a lot is because in this last General Assembly session, it was the 40 times the minimum wage was, it used to be tied to the federal minimum wage, and now it's tied to the federal or the state, whichever's higher. And the reason that's significant is the state is now higher. And so the bottom line is that if your disposable earnings, meaning your earnings after your taxes are taken out, are $380 or less a week, then you're not going to be, you can be garnished, but your wages are not going to be withheld. And that's what drives a lot of people to file bankruptcy, is a wage garnishment. And then it also, next slide, it's going to actually go up again in January because the state minimum wage goes up, and it'll be $440 a week. If you don't have disposable earnings of more than that, then they can't withhold your wages. And then this is what I started to talk about on the first slide, got ahead of myself. But this, somebody gets a judgment against you, it can become a lien on your house if they simply record it with where the deeds are recorded. It used to be, this used to be a problem because actually creditors can sell your house to satisfy this lien, which almost never happens. But I was surprised when we started digging into this, and John Whitfield found out that there is a fair amount, it happens a fair amount. And so we increased this to $25,000, which is really much more reasonable. And what's even better about this is that, so in other words, if you have a judgment against somebody, it has to exceed $25,000 before you can sell that property to satisfy it. And what's even better is that's exclusive of interest and costs. And so if you have an old judgment that's been sitting around collecting interest, it's not going to be good enough unless it was $25,000 to begin with.
I think that last point about interest not being included in in that calculation is a really huge and important point, something to definitely make note of. So, all right, we heard from Jay about a couple of, well, several different ways to help keep people out of bankruptcy. Now, Mark's going to talk about some considerations as to whether or not those ways to keep people out of bankruptcy are enough.
Thanks, Emily. Yeah, before I found my place in the legal world representing consumer debtors, I was working for a small firm in Richmond, just out of law school, and I was what I consider the world's worst creditors attorney. I actually had a commissioner in Chancery tell me once to stop being so nice to the debtors that we had at the debtor interrogatory hearings. And I just, but I was working for a firm that was not averse at all to pretty aggressive collection tactics. You just mentioned the creditor's suit and enforcing judgments by selling someone's home, Jay. That's what I was doing. I was collecting the judgments that this firm that I was working for had obtained. And one of the most heart-wrenching experiences was I was bringing a creditor's suit to sell a gentleman's house in Hanover County to enforce a judgment that probably started out at about $4,000. One of the greatest reliefs in the world happened when I got a phone call from Gail Bowman, whose name is on the wall behind me. And she said, "Hey, I'm just letting you know we filed Chapter 13 for this guy whose house I was trying to sell." So thankfully, I didn't have to follow through on that. But it's just an example of some of the types of things that we deal with sometimes that really there's not much of a better option than bankruptcy. And we'll talk about some other situations, but sometimes it's easy to file a homestead deed to get a garnishment to go away, for instance, but it's not going to stop the creditor from turning around and filing another garnishment summons. We really need to look at what the whole picture is that a person is dealing with, and you should know how bankruptcy operates, both Chapter 7 and Chapter 13.
So the reason why Mark was unable to not sell that individual's house after that individual filed for bankruptcy, and the reason why Mark was so happy to be relieved of that job, it's bankruptcy's automatic stay. Now, if there were ever a sexy part of the bankruptcy code, now just stay with me on this one, it would be the automatic stay. The automatic stay is an injunction that goes into place automatically in almost all circumstances when somebody files a bankruptcy. And what it does is it puts this wall in between a debtor and their property and their creditors. So once the automatic stay is in place, the creditors can't call the person, they can't send them letters, they can't foreclose on their house, they can't get a garnishment against them, a judgment against them. It's truly powerful. It's a wonderful, wonderful part of the bankruptcy code, and reason why a lot of people file. And not only is, well, one of the reasons why the bankruptcy code or the automatic stay is so powerful is that it has some teeth. And Mark's going to talk to you about enforcement.
Yeah, it is. The automatic stay is often called a breathing spell for debtors. We all know that of the problems that people have with debt collection and what it does to their lives. And it's great to be able to give them that chance to catch their breath. And if the creditors don't respect the fact that the bankruptcy has been filed, that they keep going, the automatic stay can be enforced. It creates a private right of action. by the debtor, and there's fee shifting. All you have to prove is a willful violation of the automatic stay, and willful doesn't require any heightened sort of intent, any actual knowledge or maliciousness or anything like that. It's just, did they get notice, and did they continue to do something that violated the automatic stay, usually attempting to collect a debt or enforcing a lien. And notice is really easy to determine in bankruptcy. Most of especially the institutional creditors, have given the Bankruptcy Noticing Center an email address to send all bankruptcy notices to. And that the notice that's given is posted on the docket report for each person's bankruptcy case. So you just look at the notice that was given. It shows the email address that went out, where email was sent giving notice to the creditor. And after that point, if they continued to do something that violated the automatic stay, you've got a willful violation right there.
Super powerful. All right, this is our rapid fire chapter choice slide. So just some different reasons why somebody might choose a chapter 7 or a chapter 13. Mark, did you want to kick off with non-exempt assets?
Yeah, chapter 7, the trustee is appointed, and the trustee's job is typically to sell any non-exempt assets. Most people don't want to lose their home or lose something else that has equity in it. So exemptions help to protect some, but if there's not enough exemption to cover a person's property, it's going to be at risk of liquidation in a chapter 7. Chapter 13 allows them instead to not worry about liquidation. Instead, they just simply have to propose a plan that repays enough to the unsecured creditors to match what they would have received in a liquidation chapter 7.
I think one thing that's cool about that change to exemptions, to the homestead exemption that Jay was talking about, is there is the potential for people down the road to just be able to cover more assets if they need to file a case again. So I could see that change actually being very impactful for some people. So yeah, non-exempt assets is one. Another difference is secured debts. If somebody has secured debts that they're behind on and they want to retain, and they don't have a bunch of cash in hand to get caught up on those debts, which people who come for bankruptcy consultations usually don't have, they might want to look at a chapter 13 so that they can reorganize those loans and pay those defaults or pay the whole loan, depending on the type, through a chapter 13 plan. Mark, do you want to take taxes?
Yep, taxes are sometimes dischargeable in bankruptcy. It's actually kind of a complicated process to figure out. For income tax, it's based upon how many years ago the tax came due, how many years ago the tax return that's associated with it was filed. But in certain circumstances, taxes can be discharged, even in a chapter 7. It usually is the older tax debt. The tax return was filed roughly on time. Of course, there is no income tax fraud involved. Chapter 13 is a reorganization that provides some sort of a framework for dealing with tax debt that has to be repaid. Some tax debt has to be repaid, is not dischargeable. And so through a chapter 13, a debtor can choose to repay that tax debt through a bankruptcy trustee over a 3 to 5 year period of time. Kind of makes it affordable. And like we talked about, during that time, they're protected by the automatic stay.
You're right when you say that the taxes are complicated. We literally have a flow chart that we use in our firm that gets into whether taxes are dischargeable, non-dischargeable, priority, So yeah, that can get super complicated. So length of case. One thing that can be great about a Chapter 7 is normally when somebody files, if it's a no asset case, which most consumer cases are going to be, they're going to get their discharge within usually about 6 months. So that you can wrap it up quickly. So that's a good thing about a Chapter 7. But I think that the flip side of that coin is that if you do have a large amount of taxes that you're trying to pay back, or if you do have a secured debt that you're providing for through a Chapter 13 plan, that's when the length of a Chapter 13 can be helpful, because you all of a sudden have 3 to 5 years that you can stretch the repayment of this debt out over, as opposed to just having to have the cash right then and there. Mark, do you want to mention flexibility?
Yep. Basically, Chapter 7, not flexible. Chapter 13 is supposed to be flexible.
Yeah, that's pretty much it.
Yeah, Chapter 7, once you file it, the debtor has very little control over the flow of the case and what happens. It's pretty much the debtor's financial affairs are managed at that point by a Chapter 7 trustee. The ability to back out, say, oops, I'd rather not be here. How about we just dismiss and let me handle it on my own? Very much controlled by the bankruptcy court, not the debtor. And Chapter 13, on the other hand, like Emily mentioned, you can stretch out debt over 3 to 5 years. It allows for basically a cash flow benefit where you can make it more affordable by stretching it out. You can modify it as a person's circumstances change to shorten it and get them out sooner, or lengthen it if they're not already at 5 years. And if they want to dismiss it, they have an absolute right to dismiss the Chapter 13. It's totally voluntary.
That right to dismiss that's kind of a really important aspect that I feel like we could probably spend a whole presentation on.
Yeah.
Maybe that's an idea for a future presentation. But yeah, also future filings, that's a consideration. Future filings and past filings. The amount of time between discharge to discharge, if you file a Chapter 7, it's so much greater. Whereas with a Chapter 13, it's not ideal, and it's not something that I would want for somebody unless they really didn't have any other options. However, people can go from Chapter 13 to Chapter 13 and keep getting discharges. So if somebody is having problems with stability, that can be a benefit. That flexibility for future filings too should be a consideration. Mark, I think, had described this aspect of Chapter 13 kind of as a soft landing. Is that right?
Yeah, and that's that's the idea. Is oftentimes when people come to us, they kind of need they need big changes in their lifestyle. They need to kind of admit that what they've been doing is not working, and oftentimes it's difficult to get people to that point. So Chapter 13 allows you to offer an option. Hey, I can get you protection from the debt collection that you're dealing with. We can give you a chance to do the things that you want to do. For instance, like keep this really expensive house that, and oftentimes we're trying to convince them that, hey, just this house is like, pulling you down. You need to let it go, especially when, real estate values a few years ago were just awful and houses were upside down, no equity at all. and we found ourselves trying to convince folks to let their house go. But people don't want to, they want to keep trying. And so, ultimately it's the consumer's choice, and Chapter 13 can sometimes give us an ability to give them a chance. And if that doesn't work, one of the nice things, going back to that flexibility idea about Chapter 13, you can convert a Chapter 13 to a Chapter 7. I know we'll talk more about that later, but if the Chapter 13 just doesn't work out for them, it gives you sort of an ability to bring them out of bankruptcy and get them a discharge, so they really have that fresh start.
So just in case we don't get to that last slide that does discuss conversion later on, I want to bring up one of the coolest things about conversion ever. It's like magic, y'all. So when somebody converts a Chapter 13 to a Chapter 7, the debt that that person incurred from the time that they filed the petition to the time that they file the conversion is included in the discharge. So it allows people to bring new debt into the bankruptcy, even though the filing date stays the same. Like, love conversions. All right. So Mark was talking about trying to convince people whether, well, sometimes it's difficult when you deal with mortgages, but here are some differences between Chapter 7 and Chapter 13 with mortgages in bankruptcy. So with Chapter 7, the individual is going to get some temporary protection from foreclosure under the automatic stay. So they'll get a little bit of a breathing spell. But as we mentioned earlier, Chapter 7 finishes up a lot quicker than a Chapter 13, which can be good. However, you don't have to stay as long, and there's no way to cure a default in a Chapter 7. So if somebody has a mortgage and they want to keep their house and they're behind on their house and they don't have the cash to catch up, which most people are not going to have, Chapter 7 is not a great option. If somebody has, let's say they have a bunch of medical debt and they're not behind on their mortgage, and there isn't any unprotected equity in their house, Chapter 7 could be a really good option. There is still the ride-through option, which just means that as long as the person keeps making the payments on the mortgage, they can keep the house, even though the debt is going to be discharged as to them personally. Chapter 13, you can cure a default through a Chapter 13. That's one of the great aspects of it. Under Section 1322B5, debtors are allowed to cure default, cure and maintain. So cure a default and maintain payments on their mortgage. The only real stipulation there, other than them being able to afford to cure the default, the last payment on the mortgage has to be due after the final plan payment under their Chapter 13 is due. And that's going to be for most people anyway. Most people who we see, I feel like their final mortgage payment is way out there. This isn't something I want to get into because it's pretty rare, but just kind of tuck this in your brain. If the last mortgage payment is due prior to the final plan payment, there are situations in which you can cram down the mortgage. And we'll talk about cram downs in the next couple of slides. Also, a really powerful aspect of Chapter 13 that can help you with mortgages is the ability to strip off junior liens. So here is the fact pattern. Let's say you have somebody who has a house that is worth $200,000 and their first mortgage is a little bit more than $200,000. We could technically say $200,001, but let's say $200,050. How about that? And then let's say that that person also has an additional lien attached to their property for $40,000. Well, even though that second lien is secured in that the lien holder has a security interest, there's no equity actually securing that lien. So one thing you can do in a Chapter 13 is have the court declare the lien as void, and then that debt would be paid as an unsecured debt through the Chapter 13 plan. That's a really, really powerful option.
Real estate taxes in bankruptcy. It's another big issue that I know that anyone who owns land, any debtor who comes into our office who owns land often owes real estate taxes. Under Virginia law, as we know, real estate taxes are secured by a statutory lien to that property. Under bankruptcy law, it is a secured debt, but it's also what's called a priority tax liability if it was incurred within a year before filing the bankruptcy. And that just means that it has to be paid in a Chapter 13, it has to be paid in full. It really has to be paid in full anyway if the person is intending to keep the property because of the statutory lien under Virginia law. And that brings up sort of a distinction between Chapter 7 and Chapter 13 that we've talked about how Chapter 13 provides for a more of a framework for dealing with things like secured debts. And that's because, it's because of a number of reasons, but one of the differences between a Chapter 7 and a 13 is that the in rem liability, that lien, remains in effect after a Chapter 7. The underlying personal liability may be discharged, but the creditor still has recourse against the property itself. In a Chapter 13, it satisfies the lien. It resolves that matter by one way or another, usually by repaying the debt with some amount of interest. But real estate taxes can be dischargeable in a Chapter 7 if it's more than a year old, but it's still going to be sitting there as a lien on the real estate. So the only way it's going to really go away is if the debtor intends to just surrender the property back to perhaps a mortgage company or someone who's going to sell it. In a Chapter 13, it's going to be satisfied, paid through a bankruptcy case. Or again, the debtor could choose to surrender that property and resolve it that way. Judgment liens. Now, this is an interesting thing. We'll talk a little bit about the differences, the way the different chapters handle judgment liens, but generally speaking, a judicial lien, as the bankruptcy code calls it, is different than a mortgage lien. The mortgage companies were able to get Congress, bribe Congress to make sure they had extensive protections from being modified. Judgment lien holders weren't there, or they didn't pay their congressman enough to get the protection that they needed. Mark
just calls it like it is. He doesn't care that this is being recorded.
In bankruptcy, that's how laws are made. You didn't believe Schoolhouse Rock, did you?
No.
522F of the bankruptcy code allows the debtor to remove or modify or eliminate a lien if it impairs an exemption to which the debtor would have been entitled. Interestingly enough, the Fourth Circuit wrote a decision, it's in the materials, that said that you don't even have to claim the exemption in order to use this to remove a judgment lien. It just has to be an exemption to which you would have been entitled. And that was a case where the debtor didn't file a homestead deed, didn't perfect that 34-4 exemption, and then later tried to remove the judgment lien. The Fourth Circuit said the judgment lien can be removed because it impaired an exemption to which the debtor would have been entitled. And this is just an example, shows sort of an illustration of how this works. Debtor owns property, principal residence, which is important because that's key to getting the $25,000 homestead exemption that we now have in Virginia. Principal residence valued at $150,000. She has a mortgage with a balance due of $125,000. And so therefore she has $25,000 in equity that can be protected using the new Virginia homestead exemption for real property. But there's a judgment lien sitting there by Claims Buyers LLC with a balance of $12,500. She can use Section 522F of the Bankruptcy Code to remove that judgment lien, to avoid it entirely. And in a bankruptcy, it would become an unsecured debt that can be discharged. Lien is void at the end of the bankruptcy case. Best practice is to get an order, separate order from the bankruptcy court that says so that you can record that in the land records, and that can, be a matter of record that the judgment lien itself is void. Now, we get into the difference between Chapter 7 and Chapter 13. If a judgment lien does not impair an exemption, for instance, the value of the mortgage exceeds or equals the value of the property, there's some disagreement as to whether it can be removed, eliminated in a Chapter 7, just simply based upon the value of the property. In Chapter 13, it's very clear that a judgment lien in that situation where it's not holding on to any equity, there's no equity that it attaches to, is completely unsecured, just by, again, best practice is to get an order, but in the Chapter 13 plan, it would reference the judgment lien and the value and say it's unsecured. It can be completely stripped off in a Chapter 13 based purely on the value, has nothing to do with an exemption issue. There's disagreement between courts as to whether you can do the same thing in a Chapter 7. And even in Virginia, there's some Eastern District versus Western District law that goes in opposite directions. And I think that's in the materials as well, but it goes back to some troublesome Supreme Court cases out of 1992 when they were first interpreting what was then a pretty new bankruptcy code and trying to figure out whether or not, now those cases were mortgage liens that they were dealing with, where the Supreme Court said, nope, in a Chapter 7, you can't strip off a mortgage, period, the end, because liens pass through Chapter 7. And they referenced Chapter 13 is a little different. Supreme Court in 2015 basically reaffirmed that decision and said, yeah, we really meant it. That's the Bank of America versus Calquette case. But we're talking about judgment liens here, and there is some other case law that does, acknowledge the difference between those Supreme Court cases that dealt with consensual mortgage liens and, on the other hand, judicial liens. So it's possible that definitely if you have a situation like that, a Chapter 13 is going to be a sure thing in terms of being able to get that mortgage lien, or judgment lien removed or stripped off. Even in a Chapter 13, at the very end of the slide there, Chapter 13 can even, if it's partially secured but not fully secured, you can even strip it down to, pay back as a secured claim a portion of it versus, dealing with the whole thing.
Thanks, Mark. Now there's this concept that Jay actually introduced me to. I hadn't heard the term before. Jay, would you tell us about heir property?
Yeah, so over my career, I've just seen a lot of clients in this situation. And what it refers to is somebody owns real estate and they die and they don't have a will. And so it automatically goes to their heirs. So, and then even, and also typically then those heirs die and it goes to their heirs. So it's not uncommon for people to come to legal aid who have a 1/15th, a 1/20th interest in some real estate. And that just causes all sorts of problems because, you know, who's supposed to pay the real estate taxes? What if they want to sell the property and they don't even know where some of the heirs are, that kind of thing. So that's where it's become a huge problem in this country, especially for Black and brown people have lost just millions and millions of dollars in this kind of property.
And we see in our office people coming in who are living in family property. The person, for instance, who in the most frequent scenario is that, you know, mom or dad owned the house, they had a mortgage on it, and they passed away, and the mortgage has gotten behind. The children are trying to keep up the payments and continue to live there, or, you know, but the mortgage company won't talk to them because their name isn't on the account. And so the mortgage company is saying, we're going to foreclose, but we're not going to talk to you about modifying or anything else. In bankruptcy, especially Chapter 13, which gives, again, that framework for dealing with secured debt and satisfying liens and curing, in this case, curing mortgage arrears. A person brings into bankruptcy all of their legal and equitable interests. If they legally own that property, then we can help them deal with the debt that's attached to it in a bankruptcy. Chapter 13 can stop a foreclosure on the heir property, just like it can stop foreclosures on, you know, a property that your name is on. So Chapter 7, again, is a different thing. It won't really help much. It only is going to deal with personal liability. And in that scenario, of course, the descendant doesn't have the personal liability. They're trying to resolve the in rem liability.
All right, switching gears slightly, not a whole lot, but a little bit. Mark is going to talk about bankruptcy when behind on rent or facing eviction.
Yeah, and of course, this is a huge issue right now with so many people facing eviction, with the moratoria that we've had in place being lifted. Huge issue, and we're starting to see that with people who have been in their rental homes for a long time and not been able to pay anything. Basically, in bankruptcy, whether or not judgment for possession has been entered is a crucial matter. If it's not been entered, then the automatic stay is going to be triggered upon the filing of a bankruptcy case. Now, the different chapters, of course, deal with this differently. Again, Chapter 13 provides more options for people who want to stay in their rental property, because there's the lease itself is what's called an executory contract. It has to be either assumed or rejected. If it's not affirmatively assumed under law, it is deemed rejected. So, and in a Chapter 7, the debtor doesn't have the control over whether or not to assume or reject an executory contract. That belongs to the trustee. And of course, the Chapter 7 trustee, that's not the trustee's interest to assume a residential lease. They're not going to do it. So it's going to be rejected in a Chapter 7. And the person is going to be on their own dealing with their landlord if they want to try to stay there. The personal liability will be wiped out. So that's a good thing in some cases, but it doesn't resolve the problem of wanting to stay in their home. Chapter 13, if judgment for possession has not been entered, you're allowed to propose to cure the arrearage. And the Chapter 13 debtor does have control over whether or not to assume or reject the lease. So Chapter 13 just gives them the ability to say, okay, I may be behind by a few payments, but I'm going to pay that through the Chapter 13 plan. And after I file the bankruptcy, I'm going to go back to paying my regular payment on time to my landlord. If judgment for possession has been entered, very complicated, and bankruptcy doesn't really give much in terms of realistic options. There is an option, but it requires the debtor to repay all their entire rent arrears into the bankruptcy court clerk's office and certify that okay, all the money that I owe my landlord that I'm behind on is sitting there in the clerk's office. Very few people have, whether you're talking about legal aid clients or Bowman law clients, very few people have that money just available. Most of the time, if they did, their landlord would gladly accept it and probably let them continue living there. So not much in terms of, unfortunately, options there in bankruptcy for someone where possession has been entered.
All right, now we're going to talk about repossessions and redemptions. So let's say the car is repossessed. There is a right of redemption actually under the Virginia Code, and that right exists until the secured creditor disposes of the property. The thing is, you have to pay it all off, including any reasonable expenses and attorney fees. So it's kind of not really practical. That similar right of redemption also exists in a Chapter 7. It is slightly better than just the Virginia Code version of a right of redemption, because the debtor may redeem the car by paying the replacement value of the car if it's underwater. But still, it requires a lump sum payment, which not many people are going to have. So in a Chapter 13, the debtor can redeem the car, demand a turnover, get it back, and then pay for that full amount over the 3 to 5 year Chapter 13 plan. The creditor can't demand payment of repo and storage fees as a condition of turnover. There is one recent Supreme Court case that's just worth mentioning, even though we don't think it really changes anything. City of Chicago v. Fulton, and that just held that mere retention of property was not a stay violation. So our bottom line that we're taking away from that case is, if you file a bankruptcy for somebody and you're having a difficult time getting the car back from the creditor, file a motion for turnover first before you file for a violation of the automatic stay. So that's really all we get from that case. All right, cram downs in Chapter 13. These are pretty cool. This is where the debtor is able to pay back the value of the vehicle as secured, as opposed to the amount of the lien. Now, if it is the debtor's primary personal, well, not primary, if it's acquired for the personal use of the debtor, then you can't cram down the car if that car had been purchased within 910 days of filing the bankruptcy. The cool thing, though, is that that's just for PMSI loans. So if you have somebody who purchased a car a year and a half ago and rates got better, they can cram down the car because that refinance broke the PMSI. It's no longer a PMSI loan. So also with cram down, you can pay back you can change the interest rate. So you're not only paying back the value of the vehicle, you're paying back what's generally the Wall Street Journal rate, prime rate, plus 1 or 2%. So in most of our cases, we're paying back the cars at prime plus 1. Might be prime plus 2 if it's a situation where they've had more than one bankruptcy that the car has been involved in, but usually in cases in this district, Eastern District of Virginia, you're going to see prime plus 1. And even if you can't cram down the car, so if you have a situation where, let's say they purchased the car 200 days ago and you can't cram it down. It's a PMSI loan. You have to pay back the full value of the lien. You can still change the interest rate. So there's still a benefit that way under Chapter 13. All right, so state court collections and bankruptcy. One thing that I sometimes think of, and I don't do this often because I don't think it's probably healthy for me to try to get myself into the headspace of an aggressive creditor. It's a little bit of an exercise, but I think it helps if you can pretend that you're an aggressive creditor and kind of play the scenario out. So you've gotten a judgment against this person, you're taking it personally, so you're mad about it. You filed a garnishment. They file a homestead deed, so you're not able to garnish them. Well, that's not necessary. It's probably not going to stop you. Probably going to keep going. You're probably going to keep trying to garnish them. You're going to keep trying to collect. You're going to be harassing them. So that's one of the things that I think about when we look at somebody's financial situation and when we look at the people who are pursuing them. If it's somebody who's pursuing a debt aggressively, they're probably not going to stop just because a homestead deed has been filed. So some other points to consider. Now, this isn't something that we have really seen much of at all with our clients, but I'm just going to mention it because it's important to keep in mind. If you have somebody who fraud, especially tax fraud, somebody who's committed tax fraud does not need to file for bankruptcy. That's probably the worst thing that they could do. Again, this is not something that I've even seen personally. It's just something to keep in mind. And Mark, I think you were going to talk about getting garnished funds returned to the debtor in bankruptcy.
Yeah, thanks. So again, the power of the automatic stay, if we're able to get a bankruptcy case filed before our garnishment return date, money that's being held by the court is supposed to come back to the debtor. In a Chapter 7, the keys are to remember to claim the money as exempt and to file your homestead deed if that's necessary. I guess that's not necessary anymore, is it? Old habits die hard. But you can get the money back if it's being held by the court. The tricky issues are where the garnishee, which is the employer, skips the step of sending the money to the court, which is what the forms that they receive tell them to do. But they skip that step and just send the money straight to the creditor, and the creditor is already holding the money when you file the bankruptcy. It can be a little difficult to get them to willingly cut a check and send money back to you. But the automatic stay again does say that that money is part of the bankruptcy estate. And so if they hold on to it and won't give it back after they get notice of the bankruptcy, they're violating the automatic stay, and we can bring a stay violation action against them. But you know, there can be, that's the big issue to be aware of if you're filing the case, is immediately start working on getting the garnishment stopped, so that it of course doesn't continue to harm the debtor and, you know, get money taken out of their paycheck, or try to get their bank account unfrozen, but also figure out where the money is that's been taken. Has it been sent to the court, or is it somewhere else?
Hey, Mark, can you
Yep.
speak super briefly on the change with homestead deeds and filing versus not filing?
Well, yeah, the filing the homestead deed, Jay, you probably can back me up on this. But filing the homestead deed, which was always really a trap, it was really a malpractice trap. You know, we had to file a homestead deed within no later than 5 days after the date of the meeting of creditors, the bankruptcy, the trustee meeting. And if we didn't, then the claim of exemption was, you know, was not perfected. The trustee could then take otherwise exempt assets. It was a big problem, of course, for pro se debtors who don't know how to file a homestead deed on their own. And it just, you know, simply harmed people who usually are the most vulnerable. But one of the things that we love about, in addition to the expanded exemption, is that we don't have to file homestead deeds anymore in most cases. The claim of exemption is right there in the bankruptcy schedules, and so there's no extra step to perfect it. Let's see, I think the next slide was the debtor's interrogatory hearing, and how to deal with that sort of situation if you're filing a bankruptcy just before a debtor's interrogatory hearing. You know, typically the state court judge is going to send out a show cause if a debtor doesn't show up for their debtor interrogatory hearing. But if you're filing bankruptcy, why should they have to go to their debtor interrogatory hearing that is scheduled for, you know, a couple of days after their bankruptcy was filed? The whole point of the automatic stay is to allow them to have a breathing spell, get the debt collection behind them, and go back to, you know, going to their job, for instance, instead of going to these hearings. We had a case.
Hey, Mark, I'm
yes.
so sorry to interrupt you. They're starting to play the music for us. I think you want us to stop and
Getting the hook.
yeah, exactly.
Well, I think we're okay. If you just go a few more minutes, I think we're all right. We'll still have plenty of time for questions.
Okay.
Well, the point is the debtor interrogatory has to stop. The creditor has to affirmatively make sure that the state court stops the process of that, you know, of the debtor interrogatory hearing, and failure, even silence, even sitting there and letting the judge continue it, and get angry at the debtor on the part of the creditor. Even silence in that situation has been held to be a violation of the automatic stay, where the creditor had notice of the bankruptcy.
So real quickly on predatory loans, the Fairness in Lending Act went into effect on January 1st. So hopefully you won't see as many of these as you have. For example, the car title lenders have left the state. So that's a good development. But what you're still going to see are old car title loans that were done before January 1st. I've seen it. I noticed a lot of these lenders were doing these as late as December last year. So people are still in them. And then you're going to see some internet lenders who are cheating and not following the law.
Yeah.
All right.
And with internet lenders, pay attention to whether the debt is enforceable. It very well may not be enforceable, and then they're unlikely to bring suit. And if that's a situation, I wouldn't file a bankruptcy for somebody just over that. I would have them revoke authorization for those auto drafts under the Electronic Fund Transfer Act. And then if the bank allows that draft to go through and you've given them enough time, properly revoke the authorization, you've sent the bank your notice of error when they let the money go through, you have a cause of action against the bank. And let's see, title loans, a lot of the differences are, it is the same as with the other loans in Chapter 7 versus Chapter 13. However, in Virginia, unpaid title loans, even though they can take the car and sell it, it can't lead to civil collection. So that's just something to keep in mind. And this is so accurate. This is a cartoon that Jay found. I would have loved to start out with nothing.
Do we have time to talk about student loans and bankruptcy?
You probably ought to at least quickly if you are.
Yeah, of course, it's a huge issue in our society right now. Huge problem for people coming out of school, go to graduate school. You've got an even bigger problem. Hopefully, you have an income that can support it. But bankruptcy doesn't give a lot of options for student loans, as we know. This Bruner certainty of hopelessness standard is what we are living with in the Fourth Circuit. The Bruner test just refers to a bankruptcy case that set up these factors that bankruptcy courts are supposed to look at. There is a little bit of a glimmer of hope. Judge Connolly in the Western District, who I think very highly of, wrote a decision recently, Bell versus U.S. Department of Education. It's there on the slide and it's in the materials. Bell, I'm almost 100% sure, is now on appeal. And Judge Connolly expected that. That's why she wrote such a wonderful opinion explaining how she views what this certainty of hopelessness standard refers to. It's not whether or not there is a certainty of hopelessness that the debtor will ever be able to begin repaying. She said that the appropriate way to look at it is within the framework of the student loan repayment options that are available that the government provides and is provided to debtors by law. Within that framework, are they ever going to pay off the debt? And she said, if they're using a income-based repayment plan that says that they pay zero, and that's not likely to change, then that debt is never going to get paid off. And she would discharge the debt under those circumstances. So we'll see what the appellate courts think about her interpretation.
And finally, this is just it's a way that we've used Chapter 13 and Chapter 7 together to help folks with medical debt that I want to mention. If somebody is undergoing treatment, we see this with cancer, where somebody already has a large amount of medical debt. They're getting creditors who are starting to be aggressive. They have added stress because of that. And they expect more medical debt down the road from more treatment. One option that can be really good for people is you can file a Chapter 13, get that situation stabilized, get them the benefit of the automatic stay, And then when they incur that additional medical debt that they expected to incur, that can later be discharged by converting that Chapter 13 to a Chapter 7. So that is, it's a great use of the flexibility of Chapter 13 and conversions. I just love conversions, y'all. They're the best. All right. Now we'll take some questions. The questions we have time for.
Okay. Great. Hi, everybody. This is Carmen with Virginia Poverty Law Center. I'm going to read the questions that are in the Q&A. Just a reminder to folks, if they do not get to your question, the presenters can still answer them after the session. So please make sure you post your questions in the Q&A in the WOVA app. So the first question we have is, can you all speak to particular hurdles undocumented clients face in bankruptcy, for example, process, consequences, etc.?
That I've seen that scenario, but I can't say that I've seen it very frequently. But undocumented people, you don't have to be a citizen of the United States to file a bankruptcy. And I'm not aware of any circumstances where an undocumented person has filed a bankruptcy and then, for instance, become visible to the immigration enforcement wing of the government, or had any negative consequences as a result. I think that they tend to have less in the way of the types of debts that we see, though, in bankruptcy. And of course, they're probably a lot less likely to come forward and ask for help. So, but I think that the bankruptcy does provide remedies for them if they need it.
Great. Okay, next question. Is there a difference in how Chapter 7 and Chapter 13 are treated for credit reporting purposes? Like, would one look better than the other for a person's long-term credit?
Yes, there is a huge, well, I'd say there's a huge difference. I think in a lot of circumstances, here's the thing, the case law with credit reporting and Chapter 13, specifically the case law with what the creditors, who would be called furnishers under the Fair Credit Reporting Act, can and can't do during the pendency of the case is not super clear. So you can have situations where somebody files their Chapter 13, they're making their monthly trustee payments, everything's great under their plan, and the creditor slash furnisher is showing more negatively on their credit. It puts you in kind of a weird no person's land there, where it's like, they can argue that it's accurate under the Fair Credit Reporting Act. You could argue that it's a violation of the automatic stay, but that hasn't been super successful. So it's kind of like a little bit of a hot potato. I do feel like I have been seeing less and less of creditors reporting that way during the pendency of a Chapter 13. So it can be good for somebody if they have a mortgage and they're making payments to get out of that case and then have that mortgage still on their credit, and it reflects that that they're making payments. So that can be good. But it really just depends. They can stay on credit for the same amount of time. It's 10 years for both. The the credit bureaus used to only keep Chapter 13 on for 7 years because it was kind of a historical carryover from when Chapter 13 wasn't considered. I don't know if I just said Chapter 7 for 7 years. If I did, I meant Chapter 13. It was a carryover from when Chapter 13 was considered not a real bankruptcy. But under the Fair Credit Reporting Act, it's 10 years for both. So really, I think it's whichever bankruptcy is going to best suit the person. And then you just kind of deal with what happens with credit after that. I don't think that it would be, I mean, you should advise people of different outcomes. Like if you have a house and you file a Chapter 7, that debt is discharged as to you personally. Your mortgage is never going to report on your credit again. But I mean, if a Chapter 7 is more appropriate, you're not behind on your house and you only have unsecured debt and you can't afford a Chapter 13, I don't know that's a reason to file a Chapter 7. So it
Yeah,
depends.
Emily, I would, to follow up on that, it's interesting in this country, the credit reports have done such a horrible job they screw up everybody's reports and it's in the news all the time. So everybody's become aware of their credit reports. And so what have the credit report agencies and the debt collectors done? They've used that as a weapon. And now they scare people about their credit reports. And I talk to people all the time that are scared to death about, I got to pay this creditor because it's going to go on my credit report. And what I try to tell a lot of people is take a look, your credit report probably sucks anyway, and don't make decisions just based on that.
Yes. I think that's the absolute best way to look at it and talk about it. Because if you're thinking about filing bankruptcy anyway, yeah, your credit is probably in a bad place. And once you get things stabilized, it's going to get better. But the best thing that you can do for your credit is to have healthy finances. So whatever you can do to get that person to stop the bleeding and get the person the support that they need, if you can help that person, that's going to facilitate good credit. That and keeping an eye on it and knowing how to do disputes and all that.
Great, thank you. And I think that leads to into this last question that we're going to have time for, and that is, does it benefit a person to file for bankruptcy if they have limited income?
Yeah, well, assuming that we are dealing with someone who has limited income, but they have a lot of debt that they can't afford, they definitely can benefit by getting rid of that debt. They don't have to worry about having their wages garnished if they're, scraping by. Of course, under the new garnishment laws, we don't have as much of a concern there, but certainly it can benefit people. And we've talked about as well about people who are sort of uncollectible for one reason or another. People on Social Security, and of course they can't be garnished anyway, but it can really provide people with a lot of peace of mind. So many people have told us over and over again that after they filed bankruptcy, they're able to sleep at night. Because just because they're not collectible doesn't mean that the collectors will stop trying. They're dealing with harassment. They're dealing with just the stress of knowing that this company is out there, that every time they pick up the phone, they've got some rude person on the other end. So yeah, it can definitely be a benefit, even in situations where they're legally uncollectible.
And just to add to that, Mark, I spoke to an individual before who was uncollectible, as Mark put it, and he wanted to file a bankruptcy to stop the collections on his credit. I think it is so important to make it crystal clear in those situations that there are ways for that person to protect their income and protect their assets without a bankruptcy. I think that is so crucial. There are people who, even after that thorough explanation, like, hey, you're on Social Security, you don't have any assets that can't be protected these ways. There are people who still, even after hearing that, do choose to file a bankruptcy to make, just as Mark said, to make the calls and nasty letters stop.
Yeah, and to follow up on what you said, Emily, about there are other ways to protect your income and your assets for some people. One way you do not want to do is a debt settlement company, because they are worthless and they don't help people. There are still some good nonprofit organizations that can help you.
Yeah.
Go ahead, Mark.
Good point. I was just going to say, good point. Yeah.
Speaking of good points, I think this is a great point to kind of bring this session that was fantastic, to a close. We are at the 10:15 mark, which is when this session was to be closed. Jay, Mark, Emily, thank you so much for your time and for sharing your knowledge on bankruptcy and when it's a good time for a legal aid client. I just want to reiterate what Carmen mentioned earlier. If your question was not answered during the session, it is within the Whova app, and either Jay, Emily, or Mark will go and answer that for you. Their emails are up on your screen. Feel free to jot them down and follow up with them. And that's it for us. Thank you so much for joining, and enjoy the rest of today's sessions.
Thanks, everyone.
Thanks again, guys.
Thank you.
Thank you.